Good morning, Jesse. How are you doing today?
I'm great. How are you?
I'm good. So, what can I do for you today?
Everything's been going great after we figured out that whole employment law issue from last week, and we hired a few people, and we've been doing a lot of business, especially from my current residence, which is my parents' house. And the problem is, an inspector came by the other day, and he actually noticed that we were running the business out of the garage. And at the same point, my parents have been nudging me to actually get some commercial real estate and actually, you know, fully dive in as this is an actual business now. And so I'm trying to just figure out what my options are and what I should do.
So, Mom and Dad want the garage back at this point. Is that what it is?
Yep, yep.
Okay, so is your sense that you think you want to lease something, or do you want to expend capital and to purchase commercial property this time? What are your thoughts on that?
It's tough to say. Right now, I don't think we have enough cash to actually put in money for a lease. I think it makes sense to maybe raise some cash and then get something big enough so we can continue to grow.
Well, this is an area of the law called property law, and there are all sorts of things to consider. Do you rent to buy? What about zoning? What are good lease terms you decide to rent? If you need more space before your lease is up, what do you do? If you buy, how you finance it, and there are programs out there for startups. Do you have to personally guarantee your lease or mortgage? But let me start by giving you an overview of property law, and then we can go from there.
So the first thing you got to know about real property and real property law is how do we define real property? And it's not just simply land and buildings. It's also trees and vegetation. It's also airspace above a building. It is mineral rights or things that are found underneath property that would be subsurface rights. And it's fixtures. So if you walk into a house, the furnace and the central air conditioner and the thermostat, those are all considered fixtures. They're part of the real property. They're what goes with the real property when it's transferred. So real property can be owned either by a possessory manner or a non-possessory manner. And so a possessory interest is such as a fee simple, a life or a leasehold estate, and it gives the owner the right to own, to possess the land. A non-possessory interest is things like an easement, a profit or license. It doesn't give the owner a right to possess the land, but it gives the owner of that non-possessory interest the right to cross over the land and to go onto the land to, for example, extract minerals or extract gas, things of that nature. Let's start with fee simple. This is the most generic version of how property is owned. And fee simple gives the owner the greatest aggregation of rights, powers, and privileges possible under American law and can be assigned to heirs. So it's something that gets passed down to the kids. The way it works is there's a conveyance, and conveyance is the fancy word saying that you transfer the real estate from one person to the other, and a conveyance from A to B creates a fee simple. And some terms you need to know. In this case, the person that is transferring the property, A in this case, is called the grantor. The person receiving the property is called the grantee. There are also things called life estates. And these are estates that last the life of some specified individual. So to take the classic law firm example, A grants Blackacre to B for B's life. What that means is that B gets to live on basically in Blackacre for the rest of their natural life. But once B dies, the possession of the property reverts back to A, and A gets to sell it or do whatever they want to do with it. So B has a life estate and has the right to be in possession, to occupy, to live on the property. They cannot, however, mortgage the property. When B dies, Blackacre goes to A or A's heirs or assigns, or some third party in the same condition, normal wear and tear accepted. In other words, things that would be typical in terms of living on a property, as long as it hasn't been deliberately ruined, but just has been kept up, but things just get old, then that's perfectly okay. A retains what's known as a future interest in the property. A gets the property back in the future once B dies and B's life estate gets extinguished. And during B's life, she can possess, use, take the fruits from the property, but not take the property itself. So in other words, B doesn't have the right to sell the property. Now, there are also leasehold estates. You can buy or you can lease. And the property owner and the lessor agreed to basically convey the right to possess and use the property for a certain period of time. So distinguish this from a life estate. A life estate is for the entire life of a person. A leasehold is for a specific period. And it can be for a periodic tenancy, in other words, a specific period of time, property you lease for 1 year. It can be a tenancy at will, which is no specified time. The landowner can come and evict and terminate the right to possession at any time. Or it can be what's known as a tenant at sufferance. This is what you usually see if there's a holdover of a lease that the landlord doesn't acquiesce to. Then the landlord can, without notice, go and evict the tenant at sufferance. And landlord-tenant law is, especially on the residential side, as a residential real estate owner, is really fraught with risk because there's all sorts of consumer protections in place for tenants, residential tenants. Now, let's get back to the non-possessory interests. So there are two big ones, and the first one is known as an easement. And this is the right to make limited use of the person's property without taking anything from the property. So a typical easement would be the easement of an electric company to come onto the property to maintain their lines. Another typical easement would be someone, an adjacent landowner, may have an easement to pass and repass over your property to go to the beach, things of this nature. And they can be sold. You can sell easements. They would run with the property. So if the person who is adjacent sells their property, typically that easement right to pass and repass over your property goes with it. Now, a profit is different. A profit is the right to go into the land and take some part of the land away. So a profit is represented by mineral rights, for example, where a company may have the right to go into a property, drill a mine, take mineral rights away, at the end of which, though, they have to return the property to the state that it was. So they got to repair any damage that they made at that time. And a real good example of these today is you see a lot of fracking companies obtaining profit rights from people. They basically buying those rights so they can go in and frack for natural gas. So if the owner of the easement profit is continuous to the owner of the land, it's said to be an appurtenant or an easement appurtenant. If the owner's property is separated, it's said to be gross. So the adjacent homeowner has an appurtenant easement. But let's say that there is someone that's one lot away on the other side of the adjacent property owner. The easement could possibly go to them as well if it indeed is in the deeds. And you would see this typically where you have a large piece of property that gets subdivided. Let's say it's on the ocean. The large piece of property is subdivided. They want to give easement rights to people to get to the beach. It increases the value of each separate lot, and so the original developer will build in these gross easements for even property owners that are not necessarily adjacent to the lot that's actually on the beach. They can be created by a deed, and physical delivery is sufficient. So they're writing a deed conveying an easement right. They can be created by will. A last will and testament can give away an easement. They can be created by contract, and that's typically what you see with these fracking deals, especially in New York and in Pennsylvania. They can also be created by implication. If there has been a habit for many years to pass and repass, and everyone assumed it was, courts have sometimes ruled that by implication it is that way. They can also be recreated by necessity. A court would rule that absent the necessity of this easement, the property is useless. Sometimes the court will basically impose an easement. And finally, by prescription, and this is where someone gets it by adverse possession. 20 years of open and notorious use. You typically think of adverse possession as ownership of property, but it can also be to obtain an easement on a property. How do you terminate an easement or profit? Well, first, buy a deed back to the owner of the land that's burdened by it. The owner can buy back the easement. Or if the owner of the land burdened by it becomes the owner of the adjacent lot, which has the benefit of the easement, it terminates at that point because the properties merge, or it's abandoned by the owner of the easement. In other words, they just simply stop using it, forget about it, no one passes and repasses, and it goes away for a long enough period of time for a court to determine that it has been abandoned. Now, you also have something called licenses. And this is the rebel right of someone to come on another's land without moving anything from the land. And the reason this is different than an easement is an easement, in essence, is in perpetuity. It lasts forever unless it's bought back or abandoned or terminated. A license is kind of like a lease for an easement in that it's only for a specified period of time. And it's a personal privilege that results from the consent of the owner of the land, and as a result, the owner of the land can revoke that license. So it's not nearly as beneficial to the person that wants the easement, but is something better than nothing. And how do you now go about transferring ownership of property? Well, yeah, you're probably really familiar with this, but typically you got a deal between a buyer, a seller, and a real estate agent. Real estate agent agrees to list the property and market it and to receive a commission for their efforts. With some of the newer real estate firms to receive a flat fee, and in essence you do the for sale by owner and they assist you for a flat fee. If there is going to be a transfer of property, you enter into what's known as a purchase sales agreement, and under law, because of something called the statute of frauds, real estate contracts have got to be in writing. You can't have an oral agreement to sell property. In it, there would be typical contingencies, typically contingency to get a mortgage to be able to afford it. There's a closing date and any escrow. Down payment is held in escrow. There's an implied warranty of habitability. In other words, that the property is not condemned unless you're buying it as is, in which case you take that risk. But absent language to that effect in the purchase sales agreement, it is presumed that there is a warranty that it will pass health inspection and building inspection requirements, and that you can limit it. And the seller has got a duty to disclose defects. And sometimes these duties can be pretty interesting. For example, there have been cases that houses that are supposedly haunted, the seller has got a duty to disclose. And one of the issues that happens is that, let's say you have a buyer and a seller, and the buyer has a contingency that it has to pass a satisfactory examination in terms of building inspection, and the building inspector comes back with a bunch of defects that the seller didn't know about, and the buyer backs out as a result of those disclosed defects. Well, now the seller has got to disclose those defects. So there's that duty to disclose. It's really a consumer protection aspect of it. The way property typically gets transferred is by something called a deed. And a deed is simply a written document that sets forth the interest of the real property to be transferred. And the components are, first of all, you got to say who's the grantor and who's the grantee, or who's the seller and who's the buyer. There's going to be words and everything intent to convey. I hereby convey my property located at whatever your address is, more fully described in Exhibit A. And Exhibit A would typically be the description of the property that you would find at the local courthouse or the local registry of deeds. There's got to be that legally sufficient description of the land. The grantor's got to sign it, and then the deed has got to be delivered. And in most states, the deed has got to be recorded at the courthouse or at the registry of deeds. The types of deeds that are out there there's something called a warranty deed or a special warranty deed, a quitclaim deed, which is common in a lot of states, a grant deed, and a sheriff's deed. And sheriff's deed is the sheriff basically takes the property for a non-payment, but there's a period of redemption that the person they took the property from has X amount of days to make good and pay up and get the property back. So with those deeds, there are recording statutes, and basically a deed, or for that matter, any interest in real property, and this would include easements, puts the public on notice of the new owner's interest in the land and prevents the previous owner from fraudulently conveying the same interest to another buyer. And that's what the recording statutes are there for. It's really so that the property doesn't get flipped several times to the same people. And the way you do this is title firms and lawyers in states where real estate conveyancing is deemed to be the practice of law conduct a title search. And they're looking to there be good, free, clear, and marketable title. In other words, there are no outstanding mortgages that have not been paid off, that indeed the grantor owns the property. And typically you will go back 60 years to make sure that the chain of title is in place and there are no defects in the chain of title. And the way you really handle this pragmatically is there's something called title insurance. And title insurance ensures that there's no defect in title, and if a claim later comes up, for example, a mortgage was not paid off or something of that nature, title insurance company steps in and handles that. And there are lots and lots of title insurance companies across the United States. It's actually very, very profitable business. So the way the typical sales process works is you typically have an offer to purchase. The seller says, great, or no, I wanted to have this term of that, but eventually you end up with an offer to purchase. And in a lot of states, the offer to purchase is deemed to be a final contract. I mean, frankly, it's my recommendation that since the offer to purchase is considered as binding a contract as a purchase and sales agreement, you just simply should go to a purchase and sales agreement. But there are different practices out there from that. But after that, you basically enter into what's known as a purchase and sales agreement. This is the one that sets out all the details of what is going to be the terms of the sale. And the most important one is to make sure that there's a mortgage contingency in there, unless you're the kind of lucky person that can pay cash. You then go get financing, and this is where the bank figures out whether or not you're credit worthy, that they're going to loan the money to you or not. More times than not, in a residential setting, people get pre-approved for this, so they know what the bank is going to loan them. The bank and the bank's attorneys or the bank's title company will typically conduct their own title search because they want to be sure the title is good, free, and clear, because they're going to take a mortgage on the property. You would then do a home inspection, make sure there aren't any hidden defects to make the property not habitable. The title examination takes place, and as part of the closing, title insurance will be issued. Down payment is made and it's held in escrow, and then everyone proceeds to the lawyer's office or the title company's office or the title insurance office or the registry of deeds or the courthouse or wherever is typically the place for the county that you're in, and the closing takes place where money exchanges hands, the deed gets recorded, and you got a new owner of the property. Now, one way not to have to pay for something is something called adverse possession. And this is a person can possess a property for a certain statutory period of time, typically 20 years, and if they do it for openly and notoriously, and there's never an objection by the owner of the property, and the owner of the property is on notice that they've been occupying the property for that 20 years, then they automatically acquire title land just as they've been conveyanced by deed. So it must be actual and exclusive. It's got to be open, visible, and notorious. It's got to be continuous and peaceable. The real owner never sent the sheriff out and said, get off. And it's got to be hostile and adverse, in meaning that the real owner is simply acquiesced to it. Do that for 20 years, and you get to own the piece of property that you've been doing. And frankly, at least in the history of the United States, adverse possession or homesteading was tried and true. Very rarely, however, except perhaps in Alaska, do you currently find it. But every now and then, it does pop up. There is also something called eminent domain. And basically, rights in property are not absolute. In other words, even if you own a piece of property, your right to the property is not absolute. There's constraints by both federal and state law, and these can be for nuisance, tax, and environmental. And the Fifth Amendment gives the government the right to take private land for public use with just compensation. The most famous case is something called Kelo versus City of New London, and this occurred in 2005. Now, typically you think of eminent domain as the state comes along and says, we're going to put the new highway through your piece of property. And what we do is we have an appraisal done on the property, we figure out what the value of the property would be for its highest and best use, and we will then pay that to you. It's called basically the pro tanto. And then you go hire a lawyer, and there's a court battle, basically a battle of property experts about what is really the highest and best use. But there's no getting around that the state or the city or the municipality or the federal government is going to be able to take the property. It's really just a matter of how much do they pay for taking the property. In Kilo, however, it was something different. The city of New London, New London was a depressed town, wanted to increase the value of the town, and a company came along and says, gee, we will locate in town if you allow us to build our plant in that residential neighborhood over there. And so it wasn't for the public benefit, such as a highway or an airport or something of that nature. It was really for a private benefit to this corporation that would ostensibly increase the tax rolls of the town that the city engaged in the eminent domain. And it was very controversial, especially because the plant that got built never really amounted to anything in retrospect. But the Supreme Court upheld it and took away homes that had been owned by these people for a number of years. There's also something called a restricted covenant. And this is a private restriction on the land and generally is binding on the personal land because it runs with the land as stated in the deed. So, for example, you will tend to see this in condo associations where you have got condominium documents limiting, for example, that you can't hang clothes outside your condo apartment. What type of thing can be visible on the patio? What should be the color that you're allowed to paint the residence? You can't park 18-wheelers, things of this nature. So these are some of the restrictive comments that you would typically see in some of these deeds. All right, so now let's talk a little bit about leasing. Let's talk about landlord-tenant. So you want to have a written lease, but it can be oral. And the reason that you don't want oral is that, first of all, it may not be enforceable, so it's not good for you as the landlord. But the lease gives the tenant the temporary right to exclusively possess the property and to have the right of quiet enjoyment. Now, what that means is the landlord can't come onto the property without notice, can't come onto the property for no reason at all. The tenant gets to use the property as long as they make their lease payments. And there's a bunch of law that supports this. There's common law, leases have been around since time immemorial. There's state and local statutes, and something called the Uniform Residential Landlord and Tenant Act, which has been adopted by at least 25% of the states. And what you find across the United States is for things like this, banking, landlord-tenant, things like the Uniform Commercial Code, there's a tendency by states to adopt a uniform practice so it's common across the United States. So possession is the landlord's got the duty to deliver actual physical possession or the legal right to possession is what's called the American rule. The tenant's right to exclusive possession is only subject to the landlord's right to come onto the property and has to be for a good cause and typically with notice. The tenant's got a covenant of quiet enjoyment by which the landlord promised that the tenant has the peace and enjoyment of the property. Now, so it's to possess and to occupy the property. The tenant can't, for example, without the landlord's consent, go dig up the property or things of that nature. The tenant has got the duty not to commit waste. So the tenant is liable for destruction or abuse of the property. However, the tenant is not liable for normal wear and tear or depreciation value over time. The tenant isn't required to keep the property as though it were original to the date the tenant possessed the property. If normal wear and tear happens, then that's okay. It is only deliberate waste that the tenant is going to be concerned about. If the tenant alters the premises, they need the landlord's consent to make material alterations. If they install fixtures, and recall fixtures are things like furnaces, central ACs, light fixtures, things of that nature, they become the property of the landlord. once the tenant leaves. Whether the tenant can remove them depends on state law and on the consent of the landlord, but in general, if you make improvement to a property with a landlord's consent, for example, you put up a new wall, well, that wall can stay, or the landlord can even make you return the property to its original condition, but you don't get to take those fixtures with you. Residential property, the landlord affirms the premises in habitable condition. Basically, he's got to pass building inspection. The landlord is responsible for maintaining common areas such as stairs, parking lots, elevators, swimming pools, things of that nature. If it's commercial property, it may still require the tenant to maintain all those things depending upon the lease terms. So residential, landlord's responsibility. Commercial, it's negotiable, but more times than not, it is the tenant's responsibility. And even to the effect that the landlord may assume doing it, but requires the tenant to pay what's known as common area maintenance, or CAM, C-A-M, charges, which is a tack on to the lease. So when you're looking at leasing a property, one of the things you've got to be keep in mind is what's it really going to cost. The landlord may tell you, oh, it's X dollars per square foot, but you then learn that it's equivalent as a triple net lease. In other words, you're in addition responsible for the property's share of utilities, the property's share of property taxes, in addition to the lease payments, and the property's share of common area charges. So all of a sudden, the quote X dollars per square foot is really X plus Y plus Z plus whatever, and is way more. And you need to be savvy about that, and it should be in a written portion of the lease. The implied warranty liability in residential it applies to substantial defects if the landlord knew or should have known, and the landlord had reasonable time to repair it. And to determine whether or not there's a breach of this, the course will consider, first of all, did the tenant cause the damage? How long has the defect existed and the age of the building? How kind of impact does the defect have on the tenant's safety and health? And whether the defect contravenes relevant statutes, more particularly relevant health and building code regulations. If you don't pay, the landlord gets to evict you. It occurs when the landlord deprives the tenant of possession of the leased property or interferes with the use or enjoyment of the property to the extent that the tenant cannot use or enjoy. And constructive eviction occurs when there's a breach of the lease or a covenant of quiet enjoyment, and it makes it impossible for the tenant to use and enjoy the property. In general, though, you have a written lease. The lease says this is the terms on which you can occupy the property. In general, you got to pay rent, you got to pay your common area charges, all that type of stuff. You cannot commit waste. If you do those types of things, the landlord has got the right to evict you. If it's a residential setting, there are a ton of rights that the tenant has got, mostly out of consumer protection type of things, including in some states the right to treble damages if the landlord acts in an unfair and deceptive manner. And it's very easy, frankly, as a landlord to fall afoul of unfair and deceptive practices, even if they're being sincere and upright. And it can be a real problem. War story, I'll tell you, is I came to represent some people that bought a piece of property at a time when we were not representing them, and the fellow at the closing that was conveying it to them said, hey, my kids are still, and my son and daughter-in-law are still living in the cottage on the property. I know they're not out today, but they promised to be out tomorrow, and on that basis they took the guy at his word. The property was conveyed. Well, sure enough, the son and daughter-in-law refused to get out. The new owner went to evict the son and daughter-in-law. The son and daughter-in-law called the building inspector's office. Building inspector came down, found all sorts of problems with the property, and that it violated building inspector codes. And the son and daughter-in-law brought in action and got treble damages against the new owner for those basically building inspection defects because they violated statute. It was a real mess. What they should have done at the closing is they should have said, sorry, we're not going to close until you get them off the property. The property needs to be free and clear of all tenants. That's one thing you want to have in a purchase and sales agreement. and then they could have paid the purchase price, and the deed could have been recorded. But because they went and did it ahead of time, it turned into the big mess that it was. We finally were able to negotiate and get the son and daughter-in-law out, and not have to pay the treble damages, even though, frankly, the son and daughter-in-law had really good legal standing, but we frankly had to do it by paying them, so they really got something for nothing. You've got to pay rent. It's the tenant's paying the landlord for the occupancy and use of the property. Is based upon agreement, custom, state statute, or can even be waived. Typically, there is also required to be security deposits. As a deposit the tenant gives to the landlord is retained for non-payment of rent or damage to the premises. So typically you see in a lease is first month's rent's due, last month's rent's due, and security deposit, which is equal to 1 month's rent, is due. And there's specific provisions as to when it's kept and when it must be returned, including that typically the landlord has got to account to the tenant every year for the security deposit and pay back to them any interest that has accrued on a security deposit, because the landlord is required to put it into a interest-bearing account, which is separate and escrowed, not commingled with the landlord's personal things. And you have to tell the tenant what bank account and where it's located, and then there is payment of interest every year. And then once the tenant vacates, the landlord has got a reasonable period of time to investigate and to make a determination of whether or not waste was committed, and if there was damage caused by the tenant, what is the reasonable value to basically get that repaired, and then that's an offset against the security deposit. There can also be late charges. That's legal if it's reasonable. Typically, it's built into lease. There can be rent escalation, and if it is not provided for in the lease of how the rent can escalate, escalation of the rent is typically deemed to be a termination of the first lease and the beginning of a new lease. And then property taxes. Now, the landlord is always responsible for the property taxes, but the lease might require that the tenant is to pay the landlord. But the landlord can't say to the town, for example, oh, my tenant hasn't paid the property taxes, go get it from them. The town will get it from the landlord. They, in turn, have to get it from the tenant. You can transfer rights. A landlord can sell any and all his rights in real property. A new owner may buy subject to the lease if the lease is recorded. So typically, if you got a commercial piece of property, multifamily apartments, for example, that type of stuff, then the lease agreements that the tenant had with the old owner, the old landlord, are binding upon the new landlord until the lease terminates. If the tenant's interest is transferred, the landlord can consent, and it may not be required by statute of the lease itself. They can be done either by an assignment, and this is that the tenant transfers their entire interest in the lease to a third person. The original tenant, however, is not released from liability under the lease. They may go and look to the transferee, but they are still on the hook to the original landlord. Or they might be a sublease, and this is again where the tenant transfers all of his part of interest in the lease for a shorter period of time. And again, the original tenant is still under contract, still under that lease agreement with the landlord, and so they're not released simply because they sublet. It can be terminated. Lease can be terminated by notice. I'm sending you notice that you haven't paid your rent, and therefore we're terminating the lease. It really, how much and what's involved is dependent upon the lease and the terms of the lease. It can be terminated by what's known as release and merger, and this is where the tenant ends up buying the property. That needs to be in writing because, again, the statute of frauds requires any conveyance for real estate to be in writing. It can be surrendered by agreement. In other words, the parties negotiate and agree to terminate it early, or a tenant can abandon it. There's no automatic termination, no writing required. But even though the tenant abandons the property, doesn't mean they're off the hook. They still got to pay the balance of the lease term in terms of the amount of rental payments that are due through the end of the lease term. The landlord can take possession. If they do that, it's considered to be acceptance of the surrender. There can be a forfeiture, and sometimes you see a clause in the lease makes termination automatic upon the happening of a certain condition. And if there's destruction of the property, in other words, a storm comes through and destroys the property by something that's outside the landlord's control, that also would terminate the lease. In that situation, the tenant doesn't owe the balance of the lease payments. A landlord's got a lien on all the tenant's personal property. So if the tenant abandons the property or fails to pay and there's an eviction, the landlord can actually look to the personal property that tenant owns and auction it off to help satisfy what's owed. The landlord can bring a lawsuit to recover possession, and typically this is what you see. For that matter, if you have an event where you're a landlord, you want to bring a lawsuit, you want to get the court to rule because it is so fraught with danger if you don't. And the landlord finally has got a duty to mitigate damages. The landlord must make reasonable efforts to re-rent the premises as an offset to what is owed for, let's say, the remainder of the lease term. The landlord has got to engage in that reasonable effort.
I feel like there's a lot of options.
So what do you think?
I'm still kind of curious if I should spend money that I could use to grow on leasing, or I should try to give up more equity in the company, getting some capital, and then getting a bigger place. I'm also curious on where I should locate the company, and I'm not too sure what the best options would be.
Okay, well, you have a lot of options and a lot of things for us to look at for you. Comparison of leasing versus buying, the issue of capitalization. There are a lot of programs out there for startup businesses where basically create jobs that can possibly help you out in terms of actually acquiring a property. But then we have the issue of whether or not a landlord or a bank or if any type of institution loaning you money would require a personal guarantee for you, which we really want to try to avoid if at all possible. So as usual, we got some great associates here. Let me have them look at this, get back to you with a written memorandum by the end of the week with what the pros and cons are for you and our recommendation as to which way would be the best way for you to go, so you can make a decision, and we can certainly get you out of your mom and dad's garage as soon as possible. So how does that sound?
Sounds great.
Okay, so we'll get back to you at the end of the week and have that memorandum from the associates for you.
Great. Talk to you then. Bye.
Okay, bye-bye.